I think it's huge news.
Yeah.
I told Joe, I said, Joe, I think we should have Barry on. And Joe said, what else is there?
And apparently there was nothing.
Barry who?
There was
I guess.
nothing. So
This is huge.
it is a huge deal because the very first time in American history, the fate of a former president is in the hands of 12 angry jurors.
Yeah.
So how did we get to this point, Barry? Set us up here. Give us a little bit of refresh our memory on who some of the key players are and what this case is about.
Yeah, I mean, this is, euphemistically, we call it the hush money case, but really this is a business records case. It's a falsification of business records. So
That sounds boring. That's why we call it the adult movie star, the hush money case, right?
Welcome to the law.
Okay.
So what happened is, back when Trump was running for office, you remember that it came down the golden elevator, the whole thing.
Of course.
And then you remember the big Access Hollywood tape came out, right?
Yes, where it was on the bus. And, yeah.
And when that happened, at that time, there were questions about whether Trump was even going to still be on the ballot, right? Whether Republicans would just say, we'll give up, let the Democrat win, we'll be done, or we're going to try to put somebody else. It was people couldn't imagine somebody coming back from that, and yet there he did. He won the whole election.
Right.
So Trump in his campaign were very concerned about that and what it was going to do with his with women votes. And there's evidence that came out in this trial from people in Trump's campaign, people in Trump's office, where they were from what they were saying. Trump said that he was very concerned about that. Women already hate me. I'm never going to get women to vote for me. What do we do? And then while this was happening, Stormy Daniels was shopping her story about having this. That she had slept with Trump, having an affair with Trump, however you want to phrase it.
This is the adult film star.
The adult film star. And then another woman, Karen McDougal, who was a former Playmate, I think Playmate of the Year, who did, in fact, have a real affair with Trump for, it was either over years or multiple years. And this was all going back into the late 2000s, 2006, 2008, 2009.
All while he was married.
While he was married. It was shortly after he'd married Melania. It was the Stormy Daniels part was when she was pregnant with Barron, who just graduated from high school, and had just had the baby, and that's what was happening. So that's why people are like, what's the difference? Is a person allowed to pay to pay someone not to talk about that we had an affair? Yes, Trump could have just done that at any point. Not illegal at all. So if I have an affair with somebody and I don't want my wife to find out about it, or I don't want KTR to find out about it, and I say, hey, I'm going to pay you this amount of money,
non-disclosure agreement.
I'm absolutely allowed to do that.
And I thought there was one here too with Stormy Daniels. So how do Michael Cohen, David Pecker, how do they come into play? And I thought there was a non-disclosure agreement. So how do we get here?
The non-disclosure agreements came in later. So they just had the affair. Nobody said a word. Then they started shopping the story around, and Trump... Stormy's story did, and so did Karen McDougal. And Trump became worried that this is going to kill me. And obviously Stormy saw he's running for president. This is my time to cash in, whatever it may be.
Okay.
So then Trump had this set up with the National Enquirer with a guy named David Pecker, who was the publisher of the National Enquirer. And they were friends for a long time. Trump would feed him stories, and he would do stuff to help Trump. They were just friends for years and years and years.
This is where we hear the word catch and kill. He would buy a story and then never publish it.
Never really did that with Trump much before. But when he said he's running for president, he said, this is what I'll do. He met with Trump, met with his people, and I will catch these stories. I will get these people who are out to get you. Because Trump was you want to call him a ladies' man. That was his persona. He didn't try to hide that. He used to go on Howard Stern and talk about it. He was very open about it.
Yeah.
So they were going to catch that stuff and kill it so it didn't come out during the campaign. That was the whole idea. And they did that. They did that with the story, the doorman who said that Trump had a baby with some other woman, which was not true, by the way.
Yeah.
They did that with other stories as well. So in this case, they worked out a deal, according to the evidence, that Michael Cohen, who was Trump's lawyer at the time and his fixer, he worked with Trump and would help take care of things. And people knew who Michael Cohen was before Trump began running for president and after. There's no secret. This is the stuff he did. He was a bully. He did anything he could to make Trump look better to help Donald Trump.
Okay.
And so he connected with David Pecker. They found out about Stormy Daniels shopping this, and they went to Stormy Daniels had an attorney. They went to that attorney and said, what are we doing? And they negotiated a deal to pay her $130,000 that the National Enquirer they acted like they were going to print the story, but really the Enquirer was going to kill it. They were going to catch it and kill it. So they did that, and that's all fine. Where it became an issue is that Trump, in his business capacity, him and his people set it up to pay. They didn't want to make the payment directly from the business, so Michael Cohen took out an equity loan on his house and paid the $130,000. He set up a dummy LLC put the money in there from his equity line, and then paid Stormy Daniels, and then obviously wanted to get reimbursed. He wanted to be paid back. Trump didn't want to just pay him $130,000 and say hush money for a porn star. So instead, they set it up as if they were paying him for legal services. So they put it in the accounting books as legal services, and they sent him, and they didn't want to have it all lump sum because they didn't want it to look like anything.
Right.
So they just set it up where they were paying him $35,000 a month, so it would look like a retainer. But they didn't do $130,000 because if you're reimbursing me for money I outlaid, but you're making it look like income, I have to pay taxes on that income. So they doubled it to $260,000, and then there were some other parts in there, so they made it even more. Ended up being like $410,000 for the $130,000, also it could be covered up. So they mischaracterized it. That's the falsified business record complaint those are the allegations, and that's where the fall and it's entry after entry after entry because this was going on month after month. The evidence was very clear that's what this was for. There was exhibits 35 and 36 were the smoking gun exhibits that literally showed on Trump letterhead that were invoices from Michael Cohen, Trump making note that we're going to pay this amount, and handwritten notes from Trump's CFO and from Cohen about what this was and how it was being paid out, what it was for. So everybody's talking about some other evidence. That's the smoking gun evidence that Trump knew what was going on. And of the 12 checks that were paid, Trump signed 9 of the checks.
All right, and I know that we've seen like copies of those checks in the past, right? That's what that's.
There's no question he signed the checks.
Okay, Barry Markson is a KTAR legal analyst. We hear 34 counts of fraud here. What you just described sounds like each one of these checks, each one of these payments is another count of fraud. Each entry into a ledger is another felonious count of fraud.
That's exactly right. So they take each piece of it as another. If they had just written one check for the $410,000 and said, here you go, it'd be one count, or maybe a couple, 3 counts. There'd be different crimes. But that was basically it. That's a misdemeanor in New York. What makes this a felony, because these are all felonies now, is the New York prosecutor, the way the law says is if you falsify business records in the pursuit of a different crime, another crime, that's a felony. So the additional crime here is election interference, that you're spending money to benefit an election, to benefit a campaign without disclosing it. That's against the law. You can't do that. If I write a check to a campaign, I have to disclose it. There's all sorts of election disclosure laws. And Trump, even if you're the business, it's his business, or you have to report that. Everything has to be reported. But they didn't want to report that as doing something for the election, so they covered that up. And that's what makes this election an election issue. And what Trump, one of his defenses was trying to point out that he was doing this to not embarrass his family. The evidence, again, the evidence is overwhelming that what Trump, this actually came out 6 months earlier when the campaign was in full force, but not after the Access Hollywood tape. And and when it came out then, Trump's like, we don't care. Either it'll come out, it won't come out. So he didn't care about his family. Where he started to be worried about it was after Access Hollywood, closer to Election Day, and what this was going to do to whether women would vote for him. And that's why he took these steps when he did, allegedly, to catch and kill the Stormy Daniels.
I have so many questions to follow up with you on. Barry Markson is our KTAR legal analyst. One of the questions that we're all asking, and we'll dive into the why on this, as the jury continues their deliberation, they got through 1 day of deliberation today, they'd have been excused for the evening. Why is it that if Trump is found guilty on any one of these counts, that we keep hearing an appeal is almost guaranteed? What is normally a misdemeanor charge in the state of New York has been amplified to a felonious charge because it was done in pursuit of committing another crime. At least that's what the prosecutor alleges. In this case, and then I want to get to the appeals process here in a minute because a lot of people are asking questions about that. One of the things that you said is that the fraud charges would be misdemeanors unless they're found to be in pursuit of another crime, which would be election interference. Conceivably, could the jury come back and say, look, the evidence is there. There was definitely fraud. There was a cover-up here as far as paying the stuff back. That means bad bookkeeping, and we're going to say that is criminal bad bookkeeping. But we don't think that it was done in furtherance of election interference. So what happens under those felony charges? They get knocked down to misdemeanors? They just go away?
No, it'd be knocked down to a misdemeanor. Or the jury could just say, we don't think the prosecutors proved enough of their case and just find him not guilty. That could absolutely happen.
Okay.
And what the Trump team was trying to show was that he was doing it to protect his family, but the law isn't because a lot of people are saying, well, what if it's both, right? What if he's trying to protect his family and he's trying to protect his campaign? The law doesn't say that it can only be the campaign; it can be partially the campaign. So if the campaign was part of the reason they were making these payments, then that's enough for that to be a crime.
So if I was stealing bread and I get caught and I say I'm stealing bread from my family, but also to sell on the street corner, then people would say, well, yeah, but it's not about the stealing bread for your family part, right?
Yeah.
Okay.
Or you could say it's both, but that's enough to be guilty of the crime.
Okay.
Yeah.
All right. So, Barry, one of the questions that we're asking here is we keep hearing about an appeal. And if he's found guilty on any of these counts, probably likely to see an appeal right away. How does an appeal work? It sounds like it's almost guaranteed.
Yeah. Well, it's not guaranteed. It's not an automatic appeal. And you don't have, you can file an appeal, but you don't automatically get it. So what an appeal is, people think all the time you can get new evidence or stuff really what it is did the judge make an error in a legal error? Did he not allow a piece of evidence in that should have been allowed in? Did he allow a piece of evidence in that shouldn't have been allowed in? So, for example, one of the things that came up when Stormy Daniels was testifying is she said that during their sex, somebody asked, was Trump wearing a protection? Mm-hmm. And she answered no. And what is that relevant? But the question is that more, will that upset the jury, for example? So it's called whether it's more prejudicial than probative. Is the information that you get from that question, from that response, probative? Is that information more strong and more important than the prejudicial effect of maybe people are going to be really upset that Trump would have sex with this porn star while he's married to Melania and she just gave birth to their son.
Right.
And it's the judge's job to make sure that question is stricken and not answered, and it was in this case?
Well, it's really the job of the attorney. So the attorneys have to object to the question. So when the prosecutor asks that question, the defense lawyer's got to jump up and say objection, and then the judge has to say overruled or sustained. If the
Did
judge,
that happen?
In many of the questions around that particular topic, Trump's lawyers did not object. And the judge said later in a sidebar, in a meeting outside of the jury's presence, I was a little surprised you guys weren't objecting to this stuff. And that was – so you have to protect the record by making that objection. If you don't do that, it's not on the judge to jump in every time he sees something. The judge can do that. In fact, the judge did do that here. The judge came in on his own accord a few times and said, you're going beyond what you need to go. Let's bring it back in. But if Trump's lawyers don't object, then there's no record of it and you can't go up and appeal. But the biggest issue, the biggest issue is, did the judge make an error, a legal error? That's the appellate right. And then the appellate court says, yes, the judge should have done this, not this, and that's how you get cases overturned.
Is it possible for a defense attorney to do, and I'm going to call it a poison pill? In other words, can they do something that they think is going to lead the judge to do something wrong in order to get ready for an appeal if their client is found guilty?
I suppose you could say that, but if you wanted to create a mistrial, you could ask questions that would potentially create that mistrial. I'll give you an easy example. If you have a lawsuit over a car accident, you're not allowed to use the term insurance. Nobody on the jury is allowed to know that the defendant has auto insurance that's going to pay whatever the jury decides to do. You just can't say it. Can't say the word insurance, can't talk about it. If you do, it can be a mistrial. So a defense lawyer could theoretically bring that in, causing a mistrial. But if you do that, the lawyer's going to get in big trouble. There's a lot of
Could the former president allege that his attorneys didn't properly represent him, that they weren't up to snuff, and could that lead to some kind of...
Yeah, but it's unlikely in a case like this where because freedom is at risk.
Because I know Trump's went through a lot of attorneys too.
Yeah, that's always something that a defendant has the right to say is I did not get effective legal representation. But that'd be hard to do here. He's paying these folks hundreds and hundreds of thousands of dollars, if not millions of dollars. He has experienced lawyers. I don't see that being an issue here. But if they made major mistakes, then you could certainly make that argument. In New York, I'll give you a quick example. The Harvey Weinstein trial. You remember that in New York where he was convicted.
Yeah.
And the New York, what we would call the Supreme Court, the highest court in New York, overturned that conviction. And the reason was the trial judge let in testimony and evidence of other women that Harvey Weinstein had allegedly raped or sexually assaulted. And the Supreme Court in New York, it's called the Superior Court there, said or the appellate court, was too prejudicial. that by bringing that in, you prejudiced the jury against Weinstein, and it was too much. You shouldn't have done that, and that's why it was overturned. So that's how these things can happen. Whether or not that sort of thing happened here, I don't know. It's hard here because the New York trials, nobody's in there with a camera, so you can't.
Right.
We're all watching this tweet by tweet from the lawyers that are in there, but you can't see it yourself.
All right, so Barry Markson is our KTAR legal analyst as we're talking about some of the appeals that might happen. And by the way, I have a billion questions. We're going to have you back in on this, much to Joe's chagrin. Barry, I see this on the Twitter machine all the time, that people say, even if this jury screws it up and they let Trump go, the prosecution can still appeal.
No.
I would say no. Is there ever a time that double jeopardy doesn't apply? I mean, can somebody come in and say the prosecution was so bad or something terrible happened?
No. What's more likely to happen is if it's a hung jury. So this is a criminal case. So you have to have a unanimous jury to convict and a unanimous jury to acquit. So there's 12 people on this jury, 12 jurors, there's 6 alternates. But 12 jurors will make that decision, and they have to be 12-0 to convict them or acquit. Is it possible that 1 or 2 or 5 say, I would acquit, and the rest say I would convict? Yeah, that's called a hung jury. Can the prosecution bring the case again? Yes. So that's absolutely possible and could happen. But the prosecutor, if he's acquitted, if 12 jurors say no, not guilty, no, that's over.
Okay. So let me do another follow-up then. The jury goes into deliberations. The judge gives jury instructions, and there's been a lot of talk about what these instructions are. When they say jury instructions, what is, for people that haven't served on a jury, or certainly haven't served on a jury like this, what are those jury instructions? What do they mean? And then what happens once the jury is dismissed? They leave the box, they go into that room, then what?
So the jury instructions are really one of the most important parts of any trial, and they're the ones we talk about the least in the public. It's the judge instructing the jury on the law of New York and the law specific to this case. So in each case, in each piece of law that the prosecution is saying that Trump violated, he violated the law. This is the law. This is the standard. You have to, did he do this, this, and this, or whatever it may be. And it'll say, in order to convict, you have to find that Trump did A, B, and C. And it lays out each of those things. And it'll talk about whether is what we call his mens rea, his did he do it on purpose sort of thing. And one of the big questions in jury instructions when they were arguing about it is willfully. Did Trump willfully know? Did he willfully commit these acts, or was it done on his behalf but he was aware of it? In other words, he wasn't willfully doing it, but so there's a lot of small gray area stuff there that can be very, very important. And that's another area, by the way, where appeals will come, is whatever the jury instructions are. If Trump loses, his attorneys can go back and say the judge gave the wrong jury instruction, and that's very often where appeals can sometimes be successful.
Barry Markson, our KTAR legal analyst. Barry, thank you so much. You have only skimmed the surface of the questions that I have for you, my friend. We will get you back to talk more about this. And, any idea how long you think this deliberation is likely to take?
I knew it wasn't going to come back today. When they get in the room, the jurors, in most juries here in Arizona, the juries will vote on a foreman. In New York, the first juror picked is the foreman. So juror number 1 is the foreman. So they'll go in. A lot of times juries will say, I've served on a jury once 100 years ago, but juries will say, let's take a quick poll. Like, kind of, where does everybody think this is? And if they all come back and say, I don't see how he could be guilty, or I think he's guilty, they're probably still going to go through the evidence. They want to be sure. They want to be thorough, especially in a case like this. Or they could come in and 2 or 3 could say, I'm just not seeing it. I don't see how he committed the crime, and everybody else sees it. And they may spend some time trying to convince each other or looking at the evidence themselves. There's 2 lawyers in that room. There are 2 engineers in that room. There's a lot of smart folks on that jury, but they're going to, in essence, play lawyer with each other, trying to persuade each other one way or the other. So it depends on where everybody is going in. Could the verdict come back tomorrow? Yeah. Would I be shocked if it comes back next week? No, I wouldn't be shocked. It could be any time between tomorrow and sometime next week.
Thanks for watching The Chris and Joe Show. Click to see more from Chris and Joe, and tap the button in the middle to subscribe to KTAR News.